Good morning to everybody.
Good morning, Chair.
How are you? How are you, Honorable Self?
Morning, Chair. Thanks.
Thank you very much.
Good morning, Chair.
Good morning. How are you, dear?
I'm good, thanks. How are you?
Thank you very much, Deputy Minister, and welcome.
I see that Honorable Breitenbach has let you down.
By doing what?
She was she not promising to give you a screen a thingy background thing?
No,
I see you still got those four-legged trees.
No, she did everything in her power. I still have to practice it on how to. She gave me everything.
Okay, so it's your technology or lack thereof.
I was born before technology.
Yeah, okay.
Thank you very much, dear.
Chairperson, good morning.
Morning, Honorable Horn. How are you?
Yeah, no, fine, and you. Maybe Honorable Breitenbach must assist the Honorable Jeffrey as well, so that the sun isn't shining so much on his face. We want him to be more in the shadows than he is at the moment. No, that's just a joke.
Honorable Breitenbach, that is the shadow, not me. The shadow.
Yeah. So, Chairperson, why I have unmuted the Honorable Breitenbach has put in an apology, please. As you might know, it's the Jewish New Year, and she is celebrating that today.
Oh, okay. No, that is noted. One day when we are physical, we will celebrate it with her. Members and everybody on the virtual platform, morning, especially a word of welcome to the Deputy Minister and his team. So yeah, I think it would be important that you flight the program for this week, because I think in light of the Constitutional Court's judgment, we have to agree on the revised program before we start with our order of business, so that we are one into how we are going to be dealing with this new situation that has arisen. We were forced by circumstances to really prioritize on what we are supposed to be doing this week. And in doing that prioritization, we firstly took into account that there is a bill that is a criminal procedure amendment bill that has got a Constitutional Court deadline. And we have to allow the NCOP space to also try and meet the Constitutional Court deadline. So we have prioritized that bill to finish it today or today, and maybe adopt the report tomorrow. There are also two bills from the NCOP, the gender-based violence bills. As we know that society is expecting that these bills should have been done and dispensed with yesterday. So we are under a lot of pressure as Parliament to process these GBV bills. There are some technical amendments from the NCOP that we need to consider.
Recording in progress.
So we have prioritized those GBV bills, and we have, I think, some time tomorrow just to start the process of the filling of vacancies for the information regulator, so that we can have sort of a timetable that is going to be agreed upon by the committee. We are advised that the term of this information regulator is coming to an end by the 1st of December. So we would want that by the time when we come back the processes, I mean, we should be starting with our interview, so that during the first sitting of the House, when we come back, the House should consider the vacancies on the information regulator. And we are also proposing that on Thursday, after the sitting of the House, we get a briefing from Parliamentary Legal Services on procedure to follow when dealing with the referral below, that is the referral from the Judicial Services Commission. We are proposing to do that on Thursday. I think the subcommittee I understand that they asked to postpone the meeting, but I think the chair of the subcommittee would take us through that. So Friday was scheduled to be the meeting of the term of the subcommittee, but that would still also, if our thinking then was that it would happen after the House, but I can see that there is a request for postponement. That is the program that we are proposing, honorable members. Is the program in order? Is there a move for the adoption of the program?
I move for the adoption of the enforced program, Chair.
Is a mover and a seconder?
Yes, Chair.
I
Steve Swart.
second.
Thanks.
Honorable Swart, seconds. Thank you very much and welcome, Honorable Swart.
Thank you. Can I just indicate that obviously with the sit-ins, I will be in and out and try to attend as much as possible, but there's also a very heavy parliamentary program that I have to attend to in the plenaries. Thank you so much for understanding, Chair.
Yes, no, we understand that, Honorable Swart. Anyone who is opposed to the adoption of the program? And none. The program is.
I oppose anyone who is opposed, Chair.
I can see you're back, Honorable Ngola. Thank you very much. The program is adopted. Can I also request, honorable members, that we adjourn at 1 and come back at 2. We adjourn for the lunch break at 1 and come back at 2, if we are not yet done. Thank you very much. Committee Secretary, the first order of the day.
Good morning, Chair. Good morning, members. The criminal procedure, the responses from the department, Chair. The response on the submission.
Thank you very much, Honorable Deputy Minister, or anyone would delegate to lead us.
Thanks, Chair. Let me maybe start. You know, this, and thanks very much for accommodating or wanting to accommodate this bill and the 2 GBV bills. DDG Kelly Pillay is here with her team, so she will speak on this, but effectively you put out the bill for public comment. There was one submission from the Centre for Child Law with 2 proposed amendments, which the department agrees with and or takes note of, and there's 2 then amendments that are proposed. That's basically it. But if I could ask then DDG Pillay's team to basically speak to it. There's 2 documents: a summary of the submission. And there was only, as I said, only 1, and then there's a draft B version of the bill, including those amendments. And it's 2 amendments, small amendments. But if I can hand over to Kelly Pillay.
Thank you very much, DDG Kelly Pillay.
Good morning, Chairperson, Deputy Minister, and honorable members. Chairperson, I think Mr. Mangena is online, but I'm not sure whether he's in a position to flight the documents. If he can just identify himself, because he's joining from an iPhone. I just want to double check if he is here before I start.
Mr. Mangena, are you in the platform? Mr. Mangena? It seems not.
Can you hear me, Chairperson?
Oh, we can hear you. Good morning.
Good morning. How are you?
I'm okay. Thanks, Mr.
Good
Mangena.
morning, DDG. Good morning, Deputy Minister and honorable members. Yes, I'm here.
Thank you very much.
Okay,
Ms.
sorry,
Pillay?
Chairperson. Dingaan, are you able to flight the presentations? Because I see you are joining from the iPhone. I can flight for you.
No, I don't have the presentation on the phone with me. It's only the connection only that I'm having, but the two documents are not with me on the phone.
Okay, Chairperson, if you allow me, I will share the presentation and Dingaan can start.
Can I proceed?
Yes, please.
Yes, thank you very much, Honorable Chairperson. Yes, indeed, as the Deputy Minister has actually indicated to honorable members that indeed we received only one submission from the Center for Child Law in relation to this amendment bill. And their proposals, the two proposals that they are citing or they are harping on relate to the meaning of publish. So the commentator is of the view that the proposed amendment to section 154, subsection 3 of the Criminal Procedure Act does not change the wording insofar as the publication of the identity of the child is concerned. And its concern is that the section might be construed by the public and some members of the media to refer only to traditional forms of media publications. So for them, they say in order to provide clarity and to minimize misinterpretations and avoid violations of rights of vulnerable groups that may arise, they propose that in addition to prohibition relating to traditional form of media publication, such publications should include social media and other online platforms. And in their submission, they proposed a wording which they, in their view, see it fit to be included in the body of the bill itself. And the wording that they propose for inclusion simply states that such publication should include any social media or electronic platform. And now the department's response in that regard is that we are in agreement with that submission because the submission seeks to secure the rights of the child, which include ensuring dignity and privacy of the child. And most importantly, the proposal seeks to ensure that the rights, in fact, the best interests of the child are realized. And in addition to that, we have the view that this will enable the criminal justice system to ensure ongoing protection of the children and to protect the children from being exposed to harsh circumstances that may have adverse effects on their development. So we are in support of that proposal by the Center for Child Law. Then the second proposal that they're raising is that which relates to the protection of individuals who have attained the age of majority, in other words, who have gone beyond the age of 18 years of age. So the commentator is of the view that a witness or a person contemplated in subsection 3, paragraph A, Roman figure 3, should be able to publish or reveal their own identity without needing a court order, except if there has been a court order authorizing their protection. Their main thrust or their main reasoning behind this is that it will be cumbersome if this is not modified to allow an individual to actually voluntarily reveal their identity, as it will require, exorbitant legal representation, which is very costly, and that will actually make the process very, very difficult to grapple with. And as the department, our response is that this view is supported, and we say an individual contemplated in section 154.3a should be able to publish or reveal their own identity without needing a court order once they reach adulthood. This will make the process user-friendly, less cumbersome. And in the process of ensuring that this is realized, we recommend that the following wording or the following ways be included in section 154 subsection 3 capital B subsection paragraph A, which will actually ensure that indeed somebody can be allowed or afforded an opportunity to just reveal his or her own identity after attaining the age of adulthood. So that's the end of where the submission extends. So in the next document, you'll notice that those proposed wordings that I cited earlier on, you'd see that they are highlighted in red color to show where each of those proposed recommendations should be located at. For example, under provision 1, we're saying that.
Sorry, Mr. Mangena, can those slides be flighted? Because we are getting into the thrust of the bill. So it will be important for us to see those slides and to follow you properly.
Okay.
Ms. Pillay? Thank you very much. You can start now, Mr. Mangena.
Okay, thank you very much, Chairperson. In the first provision, we're proposing that under section 154, subsection 3A, we're saying no person shall before, during, or at any stage after the conclusion of criminal proceedings in any manner. And in red color, you'd see that that's the wording that is being suggested or proposed by the Center for Child Law, and we saw it fit to include it in this section of the provision for it to actually cater for the concern that they are raising. So we're saying in any manner, including on any social media or electronic platform, publish any information which reveals or may reveal the identity of a child, under those 3 items. So that's where we feel that the proposed recommendation submission by the center should be located. And in this regard, then it will, cater for any manner of publicizing or publishing of any information that relates to the identity of the child, or that may have a potential of exposing or exposing the identity of the child who is appearing in our criminal justice system, be it an accused, be it a witness, be it a victim, or in the trials, in the criminal proceedings. So that's the first one. Then the second proposal that is there deals with what happens to when an individual reaches an age of adulthood, and then we saw it fit to work into subsection 3 capital B subsection A,
Mr. Mangena,
the wording that the court before which criminal proceedings. Hello, can you hear me?
Yes.
Hello.
Yes, Mr. Mangena.
Can you still hear me?
We can hear you.
Hello. Are we still together?
Mr. Mangena, let's deal with one amendment at a time.
Okay.
Allow.
Can you hear me?
Yes, we can hear you. Let's deal with one amendment at a time. Members, any comments on this section 154? In fact, section 1. Any comments?
No comments, Chair.
Honorable Nivo Trahan?
No, Chair, I said no comments.
Oh, no comment.
I agree with this amendment.
Okay. We agree with the amendment, Honorable Jala?
Yes, Chair, I wanted to also say we agree with the amendment. Thank you.
Thank you very much. Anyone opposed? Thank you. Let's go to the second one. Mr. Mangana, you can proceed to the second one.
Chairperson, it's me again. Can you hear me?
Yes, we can hear you.
Yes, I was still apologizing on the technical glitch that I was experiencing on my team. So I had to move chairs and use my colleagues' equipment to actually continue with what I was busy addressing honorable members on. So may I proceed? Or?
Yes, no, you can proceed.
Thank you very much. So I was on the second submission by the Center for Child Law, and I was busy explaining the fact that under subsection 3 capital B, paragraph A, we deemed it fit to to include the wording that will actually cater for a situation where an individual who has reached the age of adulthood can be allowed without any hindrance to expose or declare his identity to the broader public. And the proposed wording, when included in that provision, will read as follows. The court before which criminal proceedings contemplated in subsection 3 have been concluded may, on application of an accused, a witness, or a person contemplated in subsection 3A, who has attained the age of 18 years and where the court has granted an order that extends into adulthood, grant an order authorizing the publication of information which reveals the identity of the applicant. If the court is satisfied that the applicant understands the nature and the effect of the court order in terms of this subsection. So in red letters there, we included and where the court has granted an order that extends into adulthood. So in effect, this actually has the consent which was raised by the Center for Child Law, wherein there was a consent that it limited the independence or independent decision making by somebody who has attained age of adulthood, in the sense that it makes the process a little bit difficult to grapple with.
We can't hear you properly.
Can you hear me? Can you hear me?
Can you shift a bit? Can you shift a bit?
Can you hear me?
Yes, we can.
Yes. So I was busy explaining the fact that with this wording, then any individual who feels or who wants his identity to be revealed, then wouldn't have to go an extra mile, spending so much money and going through a very difficult process of trying to actually, exercising his right to interact as freely as possible with the outside world. So those limitations with the inclusion of this reading are greatly minimized. So we are of the view that this will assist in resolving or addressing the concerns that were raised by the Center for Child Law. Thank you very much. I'm not very sure if DDG would like to add something in that regard.
DDG?
Chairperson, I have nothing to add, except that we'll take questions if there are any.
Thank you very much. Members, are there any questions or comments? There seems to be
Not from
none.
my side.
Thank you. There seems to be none. Are we happy with the instructions that have been made?
Yes, Chair. I am from my side.
Thank you very much. Other members?
We are happy. Thank you, Chair.
Thank you very much. You can proceed, Mr. Mangena.
Chair, that's it.
Thank you very much. Members, do we agree that we can adopt the report on the bill tomorrow? Do I take it that we are in agreement with the bill?
Yes, Chair.
Chair, just if you pass the bill today, do you have to suspend the 3-day rule to have it in the House on Friday?
Yes, we have to. It's a new bill.
But is the 3 days not Wednesday, Thursday, Friday?
We will ask the 3-day rule to be suspended.
But do you have to suspend it if you pass the bill today?
Yes. DM.
Is the 3 days not either today, Wednesday, Thursday, or Thursday, Friday? Sorry, Wednesday, Thursday, Friday.
You can leave that to us, Mr. Executive.
Okay, no, I was just going to ask, why don't you, this committee historically likes long reports, but here the report can be brief. You had one submission, and as a result of that, 2 amendments were agreed to. Thank you very much, goodbye. But anyway, if you wanted the longer route, it's fine, and you'll suspend the 3 days, that's fine. I was just trying to be helpful.
No, thank you very much. I think, Deputy Minister, your concern is that the bill will be passed. We will take all the necessary steps to ensure that the bill is passed on Friday. Whether we would have suspended the 3-day rule or we would not have, but the bill will be passed.
I in your hands, Chair.
Thank you very much. So tomorrow we'll adopt the report, members. Can we go to the next item, Committee Secretary, the next order? What is the next order of the day?
Yes, Chair. It's the briefing on the 2 bills, Chair, the domestic violence and the sexual offences. I'm not sure which one the department will start with, Chair. Thanks.
Ms. Pillay, the Deputy Minister.
No, Chair, these are basically amendments from the NCOP. There's 2 slide presentations that have been prepared. I'm not sure which one is going to be loaded first. Just to say that in both bills, there's quite a lot of amendments because in the sexual offences bill, there was a change to correcting the phrase person who's mentally disabled. I'm not sure why the NA didn't attend to that one. And so that has resulted in a whole lot of consequential amendments. As you'll see from the slides, there are then a few other amendments, most of which are technical. And on the domestic violence bill, the issue is a lot of consequential amendments because the bill has made the act gender neutral, which was a request from some of the submissions. But anyway, there's the slides for the sexual offences bill. I'll leave it up to the DDG and the officials to go through them. Thanks, Chair.
Thank you very much, Deputy Minister. DDG Pillay.
Thank you, Chairperson. We will start with the sexual offences and then do the domestic violence. Thank you, Chair. Mr. Dupree is online and is ready.
Mr. Dupree.
Good morning, Mr. Chairperson, members of the committee and the Minister. Mr. Chair, if we look at the proposed amendments, it appears to be a lot, but there are actually not much in it, actually.
Mr. Dupree, your line is bad. We can't hear you properly.
My apologies, Chair. I'll try my best to speak harder. I think technology is going to let us down today in any event. Mr. Chair, the Select Committee proposed 3 different categories of amendments. The correction of the phrase person who is mentally disabled, and then as a result of that, there were a few sections in the Principal Act that had to be amended. It resulted in a needed renumbering of the clauses of the bill, and then there are a few technical amendments. I would just like to mention at this stage that in answer to the question just raised by the Deputy Minister, the correction of the phrase person who is mentally disabled was actually proposed by the South African Human Rights Commission in its presentation to the Select Committee. Now, Mr. Chair, as a result of that, and it unfortunately has a bit of a snowball effect on the bill itself. For example, in Section 1 of the Principal Act, which deals with certain definitions, we had to effect amendment there to replace the term or the phrase person who is mentally disabled then with the phrase person with a mental disability. That amounted to a renumbering of, or the proposal that clauses 1 to 4 should be renumbered. The new clauses, proposed new clauses in the bill are clauses 6 to 11, and those are the sections in the Principal Act where we find the phrase person who is mentally disabled, which should then be replaced with a person with a mental disability. I may immediately add, Mr. Chair, that those are the only amendments that were affected to those clauses or sections of the Principal Act, and the substance of the sections, there's no proposal for any amendment of that. So it's merely replacing the outdated phrase with a more correct phrase. Then if we can move over, there's also a few technical amendments where we had to replace the reference to a child with a person who is vulnerable, and then also the proposed deletion of the reference to where children are present or congregate, because, and this is something that we have raised in the committee, but I think the printers level gave us a one up there. So this is just a correction of something that was actually already discussed in the Portfolio Committee prior to the Portfolio Committee approving the version of the bill. Clauses 5 to 19 will then also have to be renumbered. With regard to the proposed amendment to clause 13, once again, replacing the reference to a child or a person who is mentally disabled with the phrase person who is vulnerable. The proposed amendment in clause 16 deals with the reference to, in terms of this act or any other law. That proposed amendment, Mr. Chair, must be read to the proposed amendment to the definition of sexual offence in clause 5, which aims to amend then section 40 of the Principal Act. The new clause 27 is also a consequential amendment regarding the phrase then a person with a mental disability to be replaced, or the phrase a person who is mentally disabled to be replaced with the words we see there in inverted commas. Clauses 20 to 23 merely a renumbering, and then clause 21, the proposed amendment there is to bring the long title of the Principal Act in line with the content of the bill itself. Clause 22 is then also a proposed amendment to the index of the Principal Act, and then clause 23 is the amendment of the long title of the bill to reflect the consequential amendments with regard to persons who are disabled. And that is the conclusion of my presentation of the proposed amendments, Mr. Chair.
Thank you. Thank you, Mr. De Cruz. Any comments, members? Honorable Nigo Trachens.
Thank you. Thank you very much, Chairperson, and thank you, Mr. Dupree. Good morning to everybody on the platform. I don't want to delay the passing of this bill because it is urgent. However, I would like to ensure when you are replacing a child with a person who is vulnerable, my concern is that the person who is vulnerable can also be an adult. So if you're specifically referring to a child in the act or in the bill, how do we then differentiate that it is a child if it's being replaced with a person who is vulnerable? Because a person who's vulnerable can include both categories, but when you want to specify a child, how is that done? So I'd just like some clarity on that part. Thank you, Chair.
Thank you very much. I must confess I had the similar challenge myself, Honorable Nigo Trachens. Mr. Dupree?
Thank you very much, Mr. Chair. Sorry, I'm just going to talk a bit slower to give the interpreter the opportunity to stay with me. When we refer to the term child, you must keep in mind that there are two different categories of provisions contained in the Principal Act. The first category relates to specific offences that can be committed against children. We proposed amendments does not affect that portion of the Act, where it is intended to replace the term child with a person who is vulnerable. That is only restricted to Chapter 6 of the Principal Act. And you will recall, Mr. Chair, that the committee agreed that when it comes to Chapter 6, in order to extend the ambit and protection to be afforded by the specific chapter, it was necessary then to replace any reference to a child or a person with mental disability with the defined term vulnerable person. So that is the only, and unfortunately the amendment that was proposed is actually a technical amendment to the extent that it, I hate saying this, but it was an oversight to the extent that we did not realize that in one of the sub-clauses of Chapter 6, there is still just only reference to a child, and that will bring about interpretational problems. And that is why we, or the select committee then proposed that the term should be, the correct term might be a person who is vulnerable. Hopefully, I've answered the question here.
Yes, no, thank you very much, Mr. Dupree. Any further comments, members?
None from my side, Chair.
Can I take it that we do agree with the amendments proposed by the National Council of Provinces?
Chairperson.
Honorable Jala.
I think in consideration with the explanation that Mr. Dupree have just given, and also the proposal by the NCOP, we agree.
Thank you very much, Honorable Chair. Any view that is contrary?
Chairperson, it's not necessarily a contrary view, but of course we will internally take decisions from our side. So for now, we reserve our position.
The Democratic Alliance reserves its position. So would I be correct to say that tomorrow we will adopt or will consider the report adopting this bill? Honorable Deputy Minister.
Chair, thanks. No, I just wanted to raise, I mean, obviously I know the DA always wants to reserve its position, but just to say that both the amendments to the sexual offences, criminal law of sexual offences bill, amendment bill, and the next bill that we're going to be dealing with, the amendments from the NCOP were agreed upon unanimously. So the Democratic Alliance in the NCOP supported these amendments. Thanks, Chair.
Thank you, Deputy Minister. So, members, tomorrow we will deal with the report adopting the bill. In fact, we would be finalizing the report, adopting the report, so that the bill can go to the Assembly for final adoption, debate and final adoption. Thank you very much. Can you take us through the next bill, Domestic Violence Amendment Bill?
Thank you, Chairperson. I hope my screen is visible.
Yes, it is, Ms. Pillay.
Okay, thank you, Chairperson. Chair, during the process in the Select Committee, there were several comments that were received, and I think our responses in that committee went into quite a few pages, around 70, I think, because of the nature of the comments that were made. However, if one looks at this presentation is slightly longer than Mr. Dupree, but the changes are really of a technical nature. There are one or two that make a bit of a more substantive change, which is actually an improvement to the bill. And I will deal with those when I go through those items that require that attention. The changes are essentially in three categories. One is the non-binary inclusivity that we want to achieve, gender neutrality in keeping with equality and dignity. The second is a technical amendment, sorry, Chairperson. So in keeping with that, technical amendments have been effected to replace he or she, him or her, he, she or it, or alike with a singular they, or where appropriate, them, their, theirs, or themselves, or alike. So Chairperson, I will not necessarily repeat all of this in the course of the presentation, but it's quite a few of these changes that have been effected. As a result of that, and the one inclusion from the Domestic Violence Bill, we have to renumber the clauses and therefore bring about that technical change. And generally, there are technical drafting amendments affecting readability and deleting superfluous phrases and references. Chairperson, on clause 1, there's a consequential amendment which required a rearrangement of the sections. We added 19A, period within which directives and regulations must be submitted to Parliament. The bulk of the issues that came up during the Select Committee process was in the definitions itself. We had to clarify quite a few, and Chairperson, you will note that we brought about some change in terms of some other definitions. The clarification of the definition of capture, there was a request that instead of saying prescribed in, we changed it to provide for, because they were not specifically included in 6A, but it was provide for in the directions contemplated in section 6A31. Chairperson, we've also submitted with this PowerPoint presentation the Word document of the bill that was passed by the Portfolio Committee, and the changes are indicated in color in that document. So I would rather, if the committee members want to follow on that document as well, it might be advisable, but I will stick with the PowerPoint presentation for now. To further aid the readability and clarity of application of the domestic violence, we inserted the new definition of close relationship, which means a relationship between the complainant and any other person, which the court with regard to the following criteria: the degree of trust between the persons, the level of each person's dependence on and commitment to the other person, length of time the relationship has existed, frequency of contact between the persons, or the degree of intimacy between the persons, may consider as a close relationship of a person with the complainant. Clause 2 of the definitions continued. Non-binary amendments in the definitions clause. There are some technical corrections in respect of the use of the word communication or communications or communication. In this regard, Chairperson, it's an electronic communication service provider, but electronic communication must be in the singular in terms of to retain its correct meaning and interpretation. Those changes have been effected wherever they appear. In the definition of emergency monetary relief, maintenance scope is extended. Maintenance of any child, but also including a person with a disability or older person. And it's linked to an additional contextual qualification to whom the respondent has a duty of care. With the definition of emotional, verbal, or physical abuse, the word against is replaced without, and the word wishes is replaced with the word consent. The simplification of the definition of functionary to reflect the following amendments: a medical practitioner, healthcare personnel, a social worker, an official in the employ of a public health establishment, an educator, or a caregiver. Yeah, Chairperson, this may have been a issue with the final printing of the document, but in some places we refer to caregiver with the dash and sometimes we don't, and we needed to clarify that. Any other person designated in terms of section 2A1, and that gives the power of the minister to designate further persons, which was a specific comment that was received in the select committee. We've effected several consequential amendments regarding functionary. Chairperson, with regard to the definition of harassment, there was very strong comment that we include the word stalking within the definition of harassment, and that has been done through the process. The consequential deletion of a person in a close relationship, and to replace that with the definition of close relationship, as I've just indicated. Technical corrections with regard to within the definition of physical abuse, permission is replaced with consent. There are further non-binary corrections to section 2 of the Principal Act, which speaks to the duty to assist and inform complainants of the rights. And this amendment is consequential in nature, and this is what gave rise to the change in the numbering with regard to the insertion of the new clause. Clause 3 is the definition of functionary, which I've already spoken to. The minister may, by notice in the Gazette, designate any other person belonging to a class or category of persons or who is in the employ of any class or category of entities. The numbering has been readjusted. There are non-binary technical amendments, and section 2B is a consequential numbering adjustment. The next change is in clause 5. There's a non-binary amendment here. Clause 4 on arrest. There's a non-binary amendment, grammatical correction with believes becoming believe, plain language adjustment with regard to may be prescribed to become contemplated in. Clause 6, the protection order, there's a change, a consequential reference to functionary, which has been inserted, and the list of officials. There was a misinterpretation concern with regard to the word that child, and we deleted who is under the age of 16 to bring about clarity with regard to a reference to child, because child is defined in the Constitution as a person below the age of 18. We added a reference to any supporting affidavit to align the subparagraphs, and we set a time frame of immediately in clause 6. In clause 7, section 4, safety monitoring notice, there's a simplification and clarity, clarification with regard to within the area of jurisdiction of the court to become servicing the area where the complainant resides. There's a grammatical correction with complainant to become complainants with an apostrophe S, and we corrected the spelling of Director General. Chairperson, I'm aware that we need not refer to all these changes, but we thought that we'd just refer to them as we presented it at the Select Committee. Clause 8, Section 5, application and issuing of a protection order. There was a cross-reference correction to 41B to delete sub 7 in brackets. There was a superfluous double reference to Mediation Act, which has been deleted, and that amendment has been cleaned up substantially. There's a correct contextual correction with the word order inserted after protection to now read protection order. Complainant notification, concern addressed with the expression and the return date, which needed to be where we needed to insert the word order. There's inconsistent wording which we've corrected by replacing brought to the attention of in respect of the orders to be replaced with the word served on. In clause 9, there's a grammatical correction with questions to be replaced with question. There's a time qualifier to address immediately before the word remove. A clarification by replacing form and manner with manner by means of an affidavit in the prescribed form. There's a consequential deletion of in the prescribed manner. There's a contextual correction with the word provider inserted after the word service, a cross-reference correction and deletion of superfluous wording. In clause 10, the final protection order retained the wording or is committing. I think there was an erroneous deletion in terms of the bill that was published. Notification regarding interim protection order and return date extended in sub 2A, and the amendment to not only include complainant, but to include the complainant and the respondent. That is in respect of notification of the interim order being extended. To provide for expeditious justice and urgency, the amendment for protection order to be served on the respondent within 48 hours or as soon as reasonably possible. That's an insertion. And to amend the inconsistent wording by replacing brought to the attention of with reserved on. Clause 11, the integrated electronic system. There's non-binary and grammatical amendments. Clause 12, there's a non-binary amendment. The protection scope is also extended to non-disclosure of information relating to where a complainant or related person studies. The word studies has been inserted. Clause 13 is a non-binary and grammatical amendment. Clause 14, non-binary and grammatical amendment again. Clause 15, the variation of the protection order, non-binary and grammatical amendments, and expanding the criteria which the court considers in the variation application by the addition of proper service as being effected on the respondent. Generally, we were adjusting the structure for proper readability. Clause 17, section 12 on jurisdiction. Again, we needed to bring in the inclusion of the word and studies. The clause 19, there are technical and grammatical corrections. Clause 23, technical and grammatical correction, and provides the word provide replaces the word prescribe. There's an additional requirement that has been added, and this is one of those changes that I wanted to refer to specifically. The directives referred to in this section must ensure that adequate disciplinary steps are taken against a functionary or person who fails to comply with any directive. Clause 24 on the regulations. Chairperson, here with regard to legal aid, the granting of legal aid at state expense in appropriate cases in consultation with Legal Aid South Africa to the complainant, respondent, and we added a person with a disability and older person. With regard to clause 81, there was a reference in the bill which add a section in terms of publication of legislation as part of the legislative process in terms of section 81 of the Constitution of the Republic of South Africa. That is strictly speaking not necessary, so we've deleted those references. We've inserted a section 19A after section 19. This is not substantive, it is just a technical correction. Clause 25, consequential amendment to link to clause 24, proposed insertion and the numbering. Clause 26, the directives, there's a deletion and the insertion of section 19A. The replacement is technical. On the short title, Chairperson, we had erroneously referred to the amendment as the Domestic Violence Amendment Act Amendment Bill. It's actually incorrect. It ought to have been, there's a Domestic Violence Act, so this is the Domestic Violence Amendment Bill. In the schedule, Chairperson, there's a limited amendment to the schedule to clean up the schedule to align it with the Criminal Procedure Act in respect of what it says about, if I can just go to that on my notes. Section 40 of the Criminal Procedure Act 1977 is hereby amended by the substitution in subsection 1 for paragraph Q of the following paragraph, who is reasonably suspected of having committed an act of domestic violence as contemplated in section 1 of the Domestic Violence Act 1998. We're adding the word and, which constitute an offense in terms of any law. We've deleted the rest of the amendments. Chairperson, that is the presentation on the proposals and the select committee amendments. Thank you, Chairperson.
Thank you very much. DDG Pillay. Are there any comments, members? Firstly, on the use of non-binary language, and then we will go to the technical amendments and the few ones that I think might be deemed to be substantive, the issue of harassment and stalking and reference to a child. So our view, let's say, maybe let's first deal with what is our view on the issue that has been raised of the use of non-binary language, Mr. Swart.
No, Chair, I'm trying to understand this because I do appreciate that one wants to extend the protection as wide as possible. But I'm trying to see an example, and I'm trying to see in one of the proposed amendments, for example, where it says a functionary, which is singular, who in the course of his or her duties, singular. Now we're going to say a functionary who is in the course of their duties. So to me, it doesn't make English to me. It doesn't. So where you start with a singular, you know, you're going to have to change the beginning singular to functionaries who are in the course of their duties. I do not understand the application of their language, the English language in this example. Whilst I appreciate one wants to extend the protection as broad as possible, but I'm looking at it from a purely English language perspective. And I think there is now confusion when you're dealing with a singular at the beginning, where it would have read, for example, a functionary who in the course of his or her duties. Now we're saying a functionary who in the course of their duties. That to me does not make sense. So I appreciate this is quite urgent, but it looks to me like every piece of legislation now we're going to confuse singular and plural. And from an English language perspective, I have a problem with that. But I just want to note that it's not that I'm going to, it's just an issue that I don't understand from an English language perspective. Thank you.
Thank you very much, Honorable Swart. Deputy Minister John Jeffrey.
Thanks, Chair. Look, this will be the second bill that is being made non-binary. The first was the cybercrime bill, which is now the Cybercrime Act. Similarly, in the NCOP, they wanted the pronouns changed to non-binary. A non-binary is more inclusive because you don't just have he's and she's. You've also got people who don't, could be intersex people or people who don't identify as either. As far as Mr. Swart's, so it's been done before. As far as Mr. Swart's concerned, look, it would be a functionary and they can be singular or plural, as you can be. So you have you, which is singular. You can have you, which is plural, which is sort of more unique in English as opposed to other languages. So yeah, I mean, it's moving with the times effectively, and this isn't the first bill. As I said, this amendment came from the NCOP, but it's not the first bill that this has happened to. It hasn't been done with the Sexual Offences Amendment Bill. I think the Honourable Mofokeng had raised the issue, but then it wasn't pursued. But definitely in the context of domestic violence, I think gender identity becomes very important. So I don't know if that's sufficient as of a response, but on the grammatical side, you can have a functionary and refer to they in the singular as you can have you referring to singular or plural. I hope that explains.
Thank you, Deputy Minister. Honorable Hall.
Yes, Chair, I don't want to get into this whole debate about non-binary language. For the purposes of this discussion, I will let's say accept that this is going to be something that will unfold now in respect of legislation. However, I think what will be our duty as legislators is to, I think as the Honourable Swart indicated, to maintain that balance in working towards non-binary language, to not then create a situation where legislative provisions becomes ambiguous or unclear or susceptible to different interpretations, etc. So our first and foremost duty is to make clear and understandable laws, and in that regard, with the greatest of respect, unless the English dictionary has been rewritten, there is simply no way in which they can be a singular form. They, to my mind, has always been the plural. So in that sense, Chair, I share the concerns of the Honourable Swart, and I would urge that we, whilst in the current circumstances, much may not necessarily turn on the way this has been phrased, going forward, we must be very careful not to create a situation where we will later on be asked, what exactly did you mean with this? Thanks.
Thank you very much, Honourable Horn. Ms. Pillay.
Thank you, Chairperson. I've noted what the honourable members have said and what our Deputy Minister has said. And when we were drafting the changes, I accept that we do need to be careful when we change the wording to non-binary wording, but that we don't confuse when it's being interpreted, for instance, when there's a prosecution, etc. And people are wondering, how do we word it? So I think we've got to go and look at it carefully again, but we have taken very special care to read the changes in its context and to try and understand and to try and foresee what interpretation challenges we could possibly have. So we are satisfied with the changes that we've made, but Chairperson, I think if there are any grammatical challenges, those can be addressed easily. Thank you, Chairperson. I'm not sure if I've addressed it properly.
Thank you very much. Honourable Deputy Minister.
Thanks, Chair. I just Googled they, and it seems to be definitions from Oxford Languages, and it defines they as a pronoun, number one, used to refer to two or more people or things previously mentioned or easily identified. The two men could get life sentences if they are convicted. I think that is what Mr. Horn and Mr. Swart are talking about. But then there's a two, and the two says used to refer to a person of unspecified gender. Ask a friend if they could help. So with due respect to the Honourable Horn, I can understand in a sense where Honourable Swart is coming from in terms of the position of the ACDP on LGBTI issues. I'm a bit confused with the position of the DA on the issues, but with respect, they is already there as singular. So, and as I said, this Parliament has passed, this committee has passed the Cybercrimes Bill, which was gender neutral. I'm not sure what the confusion is. And anyway, language changes, but here's a dictionary definition which refers to they in the singular. So it's not something new. Thanks, Chair.
Thank you very much. Honourable Swart, followed by Honourable Jala.
Chair, I think I'm largely covered then by that definition. If the definition of they also refers to the singular. So let's leave it at that, but it is an issue that we correctly as the ACDP would be putting down a marker on, but at the same time we would make it very clear that all persons must be worthy of full protection in terms of this legislation. And so, and so I appreciate that definition as well. Thank you, Chair.
Thank you very much, Honorable Swart. Honorable Chele.
Thank you, Chairperson. I think I'm partly answered because I was a little bit concerned when Ms. Pillay was saying they are still going to look into that issue. But if that was really, to me, it didn't sit well because I thought that today we are going to deal with whatever that the changes that has been brought before us. But now I think with the explanation that I just heard from our colleagues or my colleagues, I think I'll leave it there, Chair. For as long as we are not going to give the department an opportunity to go and decide, we have to decide on this matter today. Now, if I'm not mistaken, if from what Honorable Swart was just saying. Thank you, Chair. It was just a consent.
Thank you very much. I generally think that this issue of non-binary language is going to be a standard way of drafting going forward. So a lot of investment even in ensuring that ourselves and even officials in the department are trained to write in that way. It's going to be important that we make some investment into that. But I do think that it is going to be a standard way of drafting legislations going forward to ensure that our legislations are inclusive of everybody. Society is evolving and our legislation should also evolve. I do think that it's important that we should invest in that area, but to also ensure that our legislations, when they are drafted, they don't lead into confusion. It is why it's important that we should both on the executive side, the department, and us as parliamentarians ensure that we are geared up to ensure that we interpret and we draft and pass legislations that are along those lines. Honorable Swart.
Chair, could I ask through you that the department again looks at the issue not for the purposes of this bill, given the urgency of it and the fact that we would support a full protection of all people in terms of the proposed, but just going forward, the issue relating to how courts would interpret the words that we are replacing. So I want to make it very clear that for the purposes of this bill, we will support this. So it should not be quoted going forward that because we supported this here, that we will then always support it. But I do appreciate the protection for need, probably broadly in terms of criminal justice legislation. But I do hear, and I appreciate what Ms. Pillay said, that she will look into this going forward and the possible how courts would interpret it. Thank you, Chair.
Thank you very much. Thank you very much. Let's go to the second segment of our of the presentations, the corrections and the technical drafting that was done. Are we happy with it? There were quite a number of corrections, either some of them grammatical corrections, some of them just consequential. Are we happy with the presentation that was done by Ms. Pillay around that?
Yes, Chairperson. Because when she started doing a presentation, she explained that most of the changes that they were going to make, they were more technical. And from the presentation, I think one would say we agree.
Thank you very much. Any contrary view? None. On the issue of the insertion of stalking under harassment. What is our view? Honorable Swart, is that a new hand or an old hand?
That's an old hand. I'm removing it. Thank you, Chair.
Thank you. What is our view on the insertion of the word stalking under harassment?
Chairperson, can I come in?
Mamujela?
I'm happy with that one. I'm very much happy, Chair.
Thank you very much. Any other view that is contrary to that? Are we all happy with the insertion of stalking? I think so.
Yes, Chair, I'm happy.
Thank you very much, Dr. Nivot Drachens. On the reference to a child, are we happy with that? I think if you can go back to it, Ms. Pillay, I think it was any child, in fact, I think it was a reference to a child as being anyone who is under the age of 16. Am I correct, Ms. Pillay?
Yes, Chairperson.
Okay, thank you very much. Any comments on that, members?
Agreed, Chair.
Sorry, Chairperson.
Honorable
did you, you said the age of 16, isn't a child under the age of 18?
Ms. Pillay?
I'm just checking, Chairperson.
As Ms. Pillay is checking.
Chairperson, I'm there. Child means a person under the age of 18 in terms of the bill. And the actual reference, sorry, that was an error, but it's a child means a person under the age of 18 as defined in the bill.
Okay, thank you very much. And thank you for the correction, Dr. Nivot Drachens. Any comments on that? Are we happy with the way it has been captured?
Chair, let me just say, because I was thinking of the issue of 16 going down in consideration with the issue of the statutory rape, which is 16 downwards and all that. But if, according to the bill, it's 18 downwards, I agree with Honorable Nivot. Thank you, Chair.
Thank you very much. Any contrary view? Okay, thank you. That is all on my list. Is there any issue that members have picked up that they want to raise on the presentation that has been made? That I have not covered in my categorization of issues to be dealt with? So do I take it that we are happy with the changes that have been made by the NCOP and the bill?
Yes, Chairperson.
Honorable Jale, followed by Honorable Nivot Drachens.
My apology, Chair. We just came in because we thought that it's a long way to raise a hand. Apology for that. No, I agree, Chair. Thank you very much.
Thank you very much. Honorable Nivot Drachens.
I also agree with all of the changes as listed. Thank you, Chair.
Thank you very much. Anyone who is not in favor? None. The changes have been agreed to. Can we go back to the criminal procedure since we have been able to, we thought that we'll spend the whole day on these bills. Ms. Pillay, do you have the A list for the criminal procedure? Because I must say, I think on reflection, the Deputy Minister is correct. I don't think that we should burden the House unnecessarily so. If it's possible that we can finish the bill and adopt the report today on the criminal procedure, then I think the counting will start from Tuesday, Wednesday, Thursday, and then on Friday, then there will be no need for a 3-day rule, for a waivering of the 3-day rule. And since we are done very early, my suggestion is that if it's possible, we go through the A list, we adopt the report so that the time can start running from tomorrow. And my understanding of the rules is that with respect to the 2 bills from the National Council of Provinces, there is no need for the 3-day rule to apply. The 3-day rule will only apply to this one because it's a new bill. So if we can be in a position to conclude the bill today, I propose that we do. What is the view of the members?
Chair, I'm in agreement with your view. Let's try and finalize it today. And we can also consider whether it's, given the pressure on Friday with a lot of other legislation, whether we should just have a time of declarations as opposed to debates to save time as well. Thank you, Chair.
In fact, Honorable Swarte, you are introducing a very important point, of which I think it needs to be discussed as to our approach to these bills. Because in addition to what you have just raised, which I think is very important, we should, when the 3 GBV bills were introduced, the 2, in fact, we debated them as one. What is going to be our approach today? And I think the other issue is what Honorable Swart is raising, whether we will opt for declaration and not for a debate, which I think is important, very important, bearing in mind that we are going to be starting sittings at 10 until late. Friday is no exception. I think we will finish around after 3. So where we can try and save time for the House, I think it's important. So let's come back to the criminal procedure. There is a view that we finalize it today. It has been seconded. Is there anyone who disagrees with that view? I take it that we don't. Can we deal with the A list so that we finalize the bill and the report?
Chair, maybe if I can come in. Look, so that apparently isn't a list that's been prepared. What you've got is, and what was flighted and I think given to people, was the B list, which is the amendments actually in the bill. But an A list can be produced pretty quickly. I don't know if you want to adjourn briefly, or there was talk of you continuing at 2 o'clock. So that's also an option maybe you could consider of at 2 o'clock adopting the report, which the committee section would be doing, and then the A list.
Yes, dear. Can we adjourn and come back at 2? At 2, we'll deal with the A list and adopt the reports. Will it be fine, so that we are sure that we have done, so that tomorrow we can dedicate it to we have a number of outstanding minutes. So it will be important that as we finish the term, we are done with the minutes, and then we deal with the issue of the information regulator. So is it possible, because I'm advised by the committee secretariat that all the reports are ready, that we allow the department to deal with the issue of the A list, and then we come back at 2 just to finalize everything. Will that be in order, members? Honorable Jelle, followed by Honorable Swart.
Thank you, Chairperson. I think 2 o'clock I'll have to log that side there on the, sorry, because I have a statement, sorry for that. 2 o'clock, though I will come back after reading my statement, but I have a statement 2 o'clock, Chair. So I'm not sure if when you adopt the bill, am I not going to maybe disturb your quorum or something like that? Thank you, Chair. If you can help me with that. But I agree with 2 o'clock.
Thank you very much. I suspect we are going to get that also from Honorable Swart, because already he had that apology. Before I go to,
can we maybe meet at 1 o'clock, or will that not give enough time to prepare the document?
Yes, I was going to come to that, Honorable Swart. Deputy Minister, how long would you need?
I've just checked, Chair, with the officials. They say 12 o'clock. 1 o'clock, I think there's some problems, and you, as you'd mentioned.
Yeah.
But the officials have said within an hour, so 12 o'clock can be done.
Can we agree on 12 members so that it will accommodate both Honorable Jelle and Honorable Swart?
Thank you, Chair.
Can we come back at 12?
Agreed, Chair.
Chair, we'll come back. Chair.
One, Chair.
Honorable Ngola?
No, I just want to check, Chair, if we are going to reconvene at 12, then
Yes.
adjourn at 1 again, then meet at 2 again.
No, I think after 12, after we have done everything, after we have done work at 12, it will determine whether we'll still come back at 2, because generally we had budgeted that we are going to finish at 6. But I think we were assisted to a great deal by the efficiency of the department in dealing with this bill. So we are way ahead of time. So chances are that we might finish at 1 before and then not come back. But I think we'll be able to do that assessment when we come back.
No, that's okay, Chair. That's okay.
It's important to say this, members. I think we should really commend the department. They've done a good job. I think they have facilitated an easy decision making. They have been working under very difficult conditions, serious time constraints, but I think they've done extremely well. And I think even now we thought that we were going to spend the whole day, but they've made sure that we don't. Thank you very much, Deputy Minister, Ms. Pillay, and to your team.
Thanks, Chair. We'll see you at 12.
Thank you very much.
Thank you, Chair.
Thank you.
Chair and members, just to note quickly, we're going to use the same link when we convene at 12. We won't send out a new link. We'll use the same link.
So do we stay or
no, you
rejoin?
we can log out and rejoin.
Thanks, yeah.
Recording stopped.
Welcome back. Is the department ready to proceed?
Yes, thank you, Chairperson. We've sent the C list, sorry, the A list, and I think Mr. Mangena is online. Dingan, are you ready to take us through the document? And I believe Henk is going to flight the document if he has sharing rights, please.
Yes, if that can be flighted, that will be appreciated.
Chairperson, I'm on line. I'm using Mr. Hank's computer. Yes, we have prepared the A list, which reflects the two proposed inclusions into the bill. And I'm just trying to establish, oh yeah, there we go. What is being flagged, Chairperson, is the A list that I'm referring to. And that A list actually captures the two proposed inclusions, the proposals which were actually made by the Center for Child Law. And you'll notice that on page 2 of that bill, the words that are words that are suggested to be included in the bill actually further describe what publishing should be all about. And
Recording in progress.
as I said earlier or stated earlier on, they include publicizing the identity of an individual on any social media or electronic platform. And this is found in the bill on page 2 in line 8. And that provision will read to include any publication that appears on social media or electronic platform. Then when we move to page 3, which is in line 46, you'll see that the proposed addition in that regard actually deals with the publication of one's identity once one reaches the age of adulthood. In instances where the court has granted an order that extends into adulthood. So one would be in a position to actually be allowed to publicize his or her identity. Those were the those are the two additions that were proposed, that we captured in this list, which will be titled the A list going forward. And those are the two additions. Unless if there are any additions from DDG. DDG, do you want to add something on what is being contained in the A list?
Ms. Pillay, do you want to add anything?
You still here?
No, thank you, Chairperson. That's it from our side.
Thank you very much. Any comments, members? I think we are fine. Can we move to the report? Bonani, can you flag the report?
Can you hear me?
Yes,
Hello?
Yes, we can hear you.
Seems to be struggling with connection.
We can hear you, Mr. Mangena.
Can you hear me?
Yes, we can hear you.
Yes, I don't know at what point did we lose contact? Did I lose contact with yourselves? I was still explaining the fact that the second inclusion actually deals with the publication of one's identity once one reaches the age of adulthood. And so in section 3, capital B, subsection, paragraph A, the wording and where the court has granted an order that extends into adulthood addresses the concerns that were raised by the Center for Child Law. So in that inclusion, like I said earlier in the morning, that once that is in place, then the process won't be as difficult to really navigate through. It will actually ensure or make it easier for any person who's affected by this provision to actually exercise his or her rights going forward. Thank you. That's what I wanted to say. And I don't know if DDG would like to add something on what I've just said.
No, Mr. Mangena, we heard you, and the DDG does not have any comment. I did not see any hand that wants to make any comments on this one. That is why we're proceeding now to the report.
Thank you very much.
Thank you very much, Mr. Mangena. Thank you very much, Ms. Pillay. A report of the Portfolio Committee on Justice and Correctional Services on the Criminal Procedure Amendment Bill, dated 9 September 2021. Are there any corrections on page 1 before we move for adoption? Members, do you want to make any corrections on page 1? Let's scroll downwards.
Chair, I'm not a member of the committee, but why has September gone green?
It's Arbor Month.
Okay, sorry, I knew there was a reason. I must have missed
that. Can we scroll down? And then on page 2, can you scroll down? Down. Yes. Page 2. Can we go down? There are no corrections. Is there a mover for the adoption of the report?
Yes, Chair.
Honorable Ngola?
Yes, Chair. Having went through the report, I've seen no mistakes, no problems. I therefore move for the adoption of the report. Thank you very much.
Apologies,
Thank you
Chair.
very much.
Apologies, Chair. Honorable Woman Yuhodruchen has a question.
Honorable Yuhodruchen.
Apologies, Chair. 3.1.1 at the end it says but it just doesn't sound right there. It's either, the and should be removed, or it should be and then, connecting to the next sentence. The and just doesn't seem right there.
Ms. Stokestone, can you correct that?
Yes, I will. I'm going to take the and out and just make it a full stop at the end of each. The other thing is, I was just having a look at the heading of 2, and I think I need to just take out the word so far and just say process.
Process, okay.
Chair.
Deputy Minister.
I know this is the committee's report, so I guess technically I shouldn't be saying anything, but isn't there something missing? You explain, and look, I'm only looking at the report, that I've seen on the screen, but you explain what the bill is, then you explain about the public hearings, and then it's report for consideration. Where is it in? Shouldn't the report say that the committee adopted the bill, or is that reports the bill with amendments? Oh, it reports further. Okay. No, I guess that's okay. Sorry, I withdraw. I hadn't seen the thing. I mean, the beginning bit that's now going green as well for Arbor Month and spring. Thanks, Chair.
So you can see that John Jeffries is missing his time in the Portfolio Committee. We miss him as well.
Thanks, Steve.
No comment. Honorable Ngola, maybe I should put the question again. Is there a mover for the adoption of the report as corrected?
Yes, Chair. I hereby move for the adoption of the report as corrected. Thank you very much.
Thank you very much. Any seconder?
Chair,
Honorable Jada?
I second for the move of the adoption of this report. Thank you.
Thank you very much. Any objections?
Chairperson?
Honorable Horn?
Yeah, it's not an objection, just the reservation of our opposition, although I don't necessarily foresee that it will result in anything but support. But yeah, as per normal, we just reserve our position.
Yes, no, we understand. The report is agreed to. We note the reservation of the Democratic Alliance. The report has been agreed to. Honorable Deputy Minister.
Chair, yeah, just I might be overdoing it. Honorable Swart did raise just the issue of what happens on Friday. Honorable Swart did raise the issue of just doing declarations. But I don't know if you formally agreed to that. I mean, it's not a complicated bill as seen by the amount of submissions, but I just wanted to confirm that you were just doing declarations. You don't need a speech from the minister or myself.
No, we're going to go to that, Deputy Minister, after the adoption. Then we deal with how we are going to be processing the matter in the House. There is a view espoused by Honorable Swart that for this bill, we deal with only declarations. Am I quoting you correctly, Honorable Swart?
That is correct, Chair. Due to the pressure of Friday, and this is a very straightforward bill, I would support declarations.
Yes, thank you very much. Is there any objection? Is there any objection to that? I see none. So let's agree that we are going to do declarations on this bill. Just although it's not part of the agenda today, since Honorable Swart, you have raised the point, should we not do the same with the two GPV bills once we have adopted them, that we do declarations instead of a full debate?
I would support that as well, Chair. And in fact, we can collapse them into one. I think one declaration on both bills to save time as well. That's also for consideration of the committee. I think we previously dealt with them together as well in our debates.
Yes. In as far as the rules are concerned, Committee Secretary, since they are now coming from the NCOP, can you still proceed with collapsing them into one?
Chairperson, I'm afraid that I can't respond to that one. Maybe we can try and consult the NA table for guidance.
let's try and consult the NA table because Honorable Swart.
No, Chair, my understanding is that the items will still be separate, but they could possibly, with after consulting the NA table, that one can have an agreement that the two items will be read separate together for the purposes of declaration. So it could be item 5 and item 6, two separate issues, but for the purposes of declarations, they are taken together.
Okay. No, thank you, Honorable Swart. Honorable Deputy Minister.
No, just supporting Honorable Swart. I mean, sorry, I'm acting a bit like a committee member now. But I mean, you can do as when the bills were passed originally, there was one debate, okay, on the bills. Now it's declarations, but my understanding would be that you can do declarations on both bills, and then the questions are put separately.
So it's one declaration for both bills.
Yeah, and then you vote separately. You'll have to vote separately on each bill. I don't think you can vote for them at the same time, but I would have thought you can do that, and I'm sure it has been done before.
Okay, I think between today and tomorrow we will try and make sure that there is a consultation between ourselves and the NA table, and then before we or after we have just adopted the bills tomorrow, I think that one would be settled. But our preference for now is that we treat them as one, and then we have one declarations. Is there anyone who's opposed to that? None. Thank you very much, members. Thank you to the department for the assistance. Let's meet tomorrow. What time are we meeting tomorrow, Committee Secretary?
We're meeting at 2, Chair.
We're meeting at 2. Let's meet at 2 tomorrow at 2. Thank you very much, members. The meeting is adjourned.
Thank you, Chair.
Thank you, Chairperson.
Thank you.
Thank you.
Thank you, Chair.
Thank you very much.